Hello and welcome to episode 7 of the Parliament Podcast. I am your host, Andy Segedin, online managing editor of TLR Volume 91. Philadelphia's new Fair Workweek has grabbed more than a few local and national headlines in recent weeks, so we welcome Scott F. Cooper, chair of Blank Rome's Labor and Employment Practice Group, to explain where we are and how we've gotten here. Scott and I will also discuss the minimum wage debate, a 2018 Supreme Court decision that might have a lasting impact on arbitration agreements, and what Me Too means for employers and their workers. We hope that you find it informative and enjoy. We're thrilled to welcome Scott F. Cooper to the podcast today. Scott is currently the chair of Blank Rome's Labor and Employment Practice Group here in Philadelphia, and he served as managing editor, the Pennsylvania project for TLR Volume 65. In addition to his role at the firm, he also serves or has served as president of the Philadelphia Bar Association, member of the Temple Board of Trustees, president of Temple Alumni Association, and member of the Philadelphia Union's Fan Advisory Council. I'm going to try to limit my questions about the mascot Fangs to as little as possible. We're very happy that he's able to speak with us right before the holidays about labor and employment issues and trends in Philadelphia and abroad. And so without further ado, welcome, Scott. Thank you for having us. Well, thank you for coming on.
Well, thanks for having me on your program. Terrific to be here.
Now, I want to. I know as I mentioned, we have a good amount to discuss because this is a pretty hot time for employment law here in Philadelphia. But we always enjoy having ed board members who had previously served for us before, and kind of hearing what their experience was like. And before we start, I would like to note that you served as managing editor, Pennsylvania project, a position that we had all through the 70s and 80s and into the 90s, but that no longer exists. So for people who might have seen this in, old volumes of TLR, can you describe, I guess, what that position entailed and what the Pennsylvania project was?
Yeah, sure. I appreciate how you built it up because you made it sound a whole lot more glamorous than I think it might have been at the time. But when I was there, what seems like a very long time ago, we had a division of labor on the law review where any student-generated pieces that covered federal law went to one particular managing editor's desk, and the ones that were generated on Pennsylvania substantive law came up through the other desk, and then we tried to match articles from outside authors to match what we were doing. And I don't know that we ever thought of it so much as a standalone project as it was, subject matter driven. And so I got to be the editor that went very heavy into the Pennsylvania issues, and my equal colleague at the other desk went into all of the federal. And then, ironically, we both went on and worked for federal judges, so it all came out in the wash.
And so I guess focusing on, so you're obviously you focused on Pennsylvania law in law school. So I do want to talk a little bit about transitioning to, I guess, what's been in the news a lot lately about not only Pennsylvania law, but Philadelphia law specifically. As I mentioned, there's a lot going on in Philadelphia right now from an employment law perspective, and arguably the main thing that's been in the news is the Fair Workweek. The city council passed that a few weeks ago on December 6th. It's expected to impact about 130,000 service workers. And essentially, I'm oversimplifying here, but essentially, if you're a business that has 250 more employees and 30 locations, you have to provide schedules 10 days in advance. And if the schedule changes, there's a predictability pay that goes to the employee. And it also helps, we're supposed to help bridge the gap between part-time and full-time workers, because full-time workers who are already on staff get the first crack at available shifts. This was opposed by a lot of local business organizations, Greater Philadelphia Chamber of Commerce, the Hotel Association. Can you talk a little bit about, from, I guess, your perspective or what you've been reading about the lead up to this vote, and I guess what it might mean for employers and workers in the city?
Sure. There's a lot to talk about with this ordinance, and I think the starting point might be a little bit of historical context. It has arrived new on the scene here in Philadelphia, but this is a legislative concept that we have been following for some time, and it developed as a concept in another city to help sort of balance out what was perceived to be an injustice with short-term cancellations of workers who were not regularly scheduled, and for those who were considered to be most at risk to the ability, frankly, to earn a paycheck in a given week when the employer would simply drop the person off the schedule. The flip side of how we got there is with an increase in technology that has allowed employers to better track when they perceived customers would be on location. The concept was referred to in a business journal as micro-scheduling or micro-staffing. And the clash of these two concepts of employers really only wanting people there when they really need the people, and the disruption that has because the shifts might not go a full 8 hours, or they might not be as predictable, or a shift on a Friday might be busier than a shift on a Thursday. You have this clash that at the local level, ordinances like this, we're trying to step in and balance out the disruption to the workers versus the cost savings to the employer for not having to keep people on the floor or in the building when they really don't need them. So long answer, it's divisive depending on which side of the management or labor side of the divide you might fall, and that's how we get here. Philadelphia is a little more expansive, and that's why I think you're seeing such pushback from the hospitality industry, where they're claiming this isn't necessarily applicable to them, but in Philadelphia it will be. And so as I said, it's a very complicated ordinance, but how we got here, for those of us who have been following this for a long time, this is actually not a surprise.
And you just mentioned, and I was reading some articles in anticipation for our call, and to your point, this is, I guess, in a lot of ways not new because other cities have done this, but it's, I guess, between the predictability fee, which I think one commenter I read said gives this some teeth, and B, as you mentioned, this is not limited to retail workers like maybe some other ordinances
Correct.
or proposed ordinances. So I guess, do you believe that other cities and corporations are looking on and seeing how this is playing out in Philadelphia? And I guess, do you see this being a trend in employment law?
Yeah, I think that's a terrific question. When you're in the space that I'm in, we talk a lot, and forgive me for borrowing a concept from sports, but it is what we refer to as a copycat league. And
Sure.
what I mean by that is a city somewhere in the country, frequently California-based or even New York City, will dabble in a social experiment along this line. They will fight the fight at the legislative level. The mayor may adopt it eventually, and it often is very, very difficult to get through the first time. You'll see some of these cities pass these ordinances on a number of occasions only to fall short. But once the first city creates it, and the sky doesn't completely fall, and other cities watch how the legislative process worked, it becomes much easier for city number 2 to implement this type of ordinance than it was for city number 1. And city number 3, it's even easier than the first 2, et cetera, and it just goes on, because each time the bill comes up in a particular city, they can point out that when they did it in New York or Los Angeles or Atlanta and the sky didn't fall, we should be able to do it here. And without getting into an element of partisan politics in this podcast, a lot of this is happening at the city level because the cities tend to be, on balance, more pro-worker than rural climates or in the Midwest, for example.
Mm-hmm.
And that's why you see the trend starting in the major cities with heavy concentration of blue-collar workers, often those being paid right at minimum wage, and city government that is responsive to that. So you asked a minute ago if it's a trend. Yes, it's absolutely a trend, and it's not just this. This is exactly the pattern that was followed with banning smoking outside of buildings and inside of offices. It was the same trend that went with criminal background checks. And if you notice the common pattern here, this is all local legislation. It's not at the state level. It is certainly not at the federal level right now. And so, yeah, there's an element of one city does it, the rest copy, and then enough of them do it, and it does become a trend, if not the new normal.
And you just mentioned that this is common, I guess that's a starting point in California, New York City, which, as you mentioned, without getting too political, are areas where that do tend to be more progressive, more worker friendly. And you also mentioned minimum wage. Also on December 6th, the council voted to increase the minimum wage for city workers and for contractors and subcontractors employed by the city to $15 per hour. This is obviously quite different than things you've seen in areas like Seattle, for instance, with the minimum wage. But our last guest from a few weeks ago mentioned, Philadelphia does have the title of the poorest big city in America, has the lowest minimum wage in the region. I guess looking at both sides of the issues, is this, to use some of your terminology before, kind of testing the waters to see, what Philadelphia is going to be like minimum wage wise as a city? And do you, I guess, see any change in the next 2 or 3 years, I guess, moving beyond the just increasing it for, city employees?
Yeah, I think it will likely go up, and I think it will be mandated. One thing we haven't talked about that I think may help your listeners with an oversimplified context of all this. When we talk about this type of legislation, I always find it helpful to create a visual, even on a podcast or radio, of a wedding cake. And the lowest level of that wedding cake is the federal government, and it can pass any laws it wants. But in this country, under both the supremacy clause and the way, really since the 1930s, we've set up labor law, states and then cities are permitted to pile on top of that any protection that is more pro-employee, that is not expressly preempted by the higher rung of government. So the absence of something close to a $15 minimum wage at the federal level only sets that the floor can't go below the federal level. If the state of New Jersey or the Commonwealth of Pennsylvania want to pass a higher minimum wage, obviously they're free to do that, and the cities are free to do that on top of it, unless one of the other two branches says you are precluded from doing that. And that's actually one of the fights that happens in Pennsylvania all the time. Mm-hmm. So with that context in mind, yes, we're back to the copycat notion of local legislators sticking up for, in effect, their constituent base to get as high a wage rate as is sustainable, recognizing, especially in the Northeast, that you don't have to drive a great distance to be in a geography where that rate may drop a lot, and that can attract workers into the city, or it can drive businesses out of the city. And that's the political trade-off that happens in every one of these localized arguments. When the core downtown area across the country wants one rate, the suburbs want another, and if you drive further out, they may have their own.
And this exact, I guess, dynamic that you're describing kind of leads me to my next question, which was, again, I was reading, a couple of Philly Inquirer articles that came out right after the December 6th meeting, rather, and the suggestion there was to pump the brakes on, I guess, some of the excitement, as you're alluding to. People see a $15 minimum wage, and even though it's not citywide, it does start some conversations. But the suggestion was, A, these are hard laws to enforce, and B, to the supremacy issue that you just referenced, State Representative Seth Grove has proposed a state bill that would prohibit municipalities from instituting workplace laws. And I guess the idea, as you just mentioned, where I guess the belief is that it'd be untenable to have one minimum wage in Philadelphia. You drive a half hour, you're in another area, then you drive across the state, and you're in Pittsburgh, and it's a different one. And I guess they don't want to have scattered workplace rules. As much of your work does come, I assume, at least, in helping employers comply with what's in place, I guess, can you share your thoughts on those 2 points? I guess, A, the difficulty in enforcement, and B, I guess, navigating through different laws in sometimes very close jurisdictions?
Obviously, my client base is overwhelmingly employer, and many of the employers don't want the higher rates because it is quite simply a added cost, which in most of our clients' view doesn't truly improve the quality of the workers coming in anyway, because the same people will work there. It's more of a political issue than it is an economic issue. But of the many arguments made against the higher rates, I have to be candid. The argument about enforcement is not a particularly strong one. Almost all employers use a standard payroll company, which has to turn over their records for almost computer-generated types of audits. And so unless a company is literally going out of its way to intentionally evade the law, the enforcement piece is actually pretty straightforward. The one exception to that is workers that do work inside and outside of the city, depending on the particular law, if the rate has to apply to just where work is performed or where their main base of operation takes place. And then the sort of third leg of this stool, which we haven't talked about, which is on the other side of the equation, are the much higher tax burdens, the city wage tax, business privilege tax, that also don't necessarily apply if you drive across the street to a different jurisdiction. So some of the complaints that are happening now are not just that the rate itself is higher, but the rate itself is higher on top of an already higher tax burden. And that's where you start to see businesses that have a choice saying they're going to move outside of the city or relocate to a different part of the state.
And do you see, I guess, so, I guess with the state proposal and what's being discussed in Harrisburg right now, do you see, so obviously you said that the enforcement isn't an issue, but I guess is the issue, I guess is the issue that you can, I guess, do this cheaper somewhere else, or is the issue that is it the issue managing, I guess, different laws or different requirements in different places? I guess
Yeah,
yeah.
no, I think it's a terrific question. I actually think the answer is a tad bit more complicated, and that is there has been a long history in Pennsylvania of fighting within the constitutional structure of what municipalities are permitted to do and what they are not permitted to do. And if we can take a step back, if you look at the federal constitution, which is a very, very limited structure of government with the presumption that the states can do everything they're not expressly told not to, Pennsylvania, in a gross simplification, looks at it the other way around. The Commonwealth is the primary branch of government, and municipalities get to do whatever they're told they can do. And so the legislation that you're talking about now, which comes up, in everything from school funding debates to local legislation, even over things as volatile as gun laws sometimes, is does the Commonwealth give the city the permission to regulate in this area? And that's a very complicated legal and constitutional question that if it breaks in the Commonwealth's favor and the law goes through, then the city would literally be without the authority to pass a higher local wage rate. If the Commonwealth cannot preempt that area, then it's right where we're talking about today, which is the cities will make their own decision for both local political and economic reasons.
Now, I would like to that's. I mean, I'm sure we could probably talk for hours just on that one subject.
Absolutely.
But I guess a you're being very kind with your time now, and B, just to I guess get in some other interesting things that have been going on in employment law that are beyond just what we're talking about here in Philadelphia. I would like to start, I guess, talking about some other trends that we've seen, even in our limited capacity as just kind of students. And I guess more generally, just to start off with, every spring our articles team, as you probably well remember, gathers a ton of articles that come in and looking to select outside authors for the next volume. And I was talking to our lead articles editor really at the beginning of the process, and he noted that employment law was really an area that there is a ton of new scholarship on. There's a lot of articles flowing in on focused on employment law. And I guess this might be kind of like a silly starter question, but from your perspective, I guess, why is that? Is there something different or more rapidly evolving about employment law now as compared to when you started your career? Is it just, more employment lawyers want to start writing? I guess, what have you seen?
I think it's, in one respect, I don't think this is actually a new trend. I think it's just one that goes in sort of peaks and valleys. And again, everything in the employment legislative arena ultimately ties back to politics. And I don't necessarily mean Republican and Democrat. I just mean social issues that legislators feel they have to weigh in on. And if we go back for context to the 1930s, which I think is really the defining point of the modern labor era, everything that we're talking about today had some, whether it was minimum wage or child labor or even something as basic as overtime, all started as a legislative reaction to what people perceived to be a wider social problem, whether it was wages or abuses in factories. When we move into the 1960s, it was about workplace rights along racial, religious, national origin lines. The fights that are being fought now over gender equality and gender identity issues, whether those are federal or local, it is always in response to where the fight on these issues is socially, and again, depending on your viewpoint, you can be on two different sides of the same question, but that's where it comes from. But the one thing that is always in common is that these laws are not necessarily passed to be cohesive with one another. Congress has the right to just throw a new law out there when it wants, and then it's left to the courts to figure out how they will be reconciled. And every time that happens, you get new scholarship in that area, you get new lawyers testing the bounds. I give you one concrete example. We've had since the early 1990s a Family and Medical Leave Act at the federal level. You also have the Americans with Disabilities Act. When those two laws were passed, they were completely separate concepts, and they were supposed to be addressing separate topics. But all these years later, those two have woven together and have judges looking from one law to borrow precedent for another and how they interpret it. And so each time this occurs, it is just ripe for people to put articles and speeches out there on what they think it means and where they think the law ought to go next. And finally, and I'm sorry it's a long answer, but
no.
I think you've asked a great question. It never stands still, and that's that there's always going to be some new driver, some new issue in the workplace, because the economy doesn't stay the same. One of the things that's really interesting about the U.S. employment system that is different than perhaps Europe is we pass laws of general application, and then we leave it to the various agencies to apply those laws in specific situations. So, for example, we have one overtime law in this country. It's not an overtime law just for hospitals or for factories or restaurants. It's one law. And then the Department of Labor will weigh in on how it applies to that factory, that nurse at the hospital, the person that's going to clean up the fry cook in the restaurant. And because they are laws of general application following specific interpretations, you sometimes get to some very unusual results that may not have been originally contemplated. And then again, people have to write about it, they have to advocate for it, and then you have to figure out where it will all go. And then add to that the economy is constantly changing. The laws 20 years ago that were for brick and mortar stores that are still out there may not be as directly applicable to, say, the cyber climate we live in, or the mass distribution, say, from Amazon, or a big box store replacing Main Street. And the law doesn't just stop and not apply. They adapt it to whatever is out there in the current workforce. So you put all these different things in the soup, and I think you understand why you get a very ripe culture for a lot of additional scholarship and a lot of different, business and law schools beginning to more focus on these areas. And then as soon as you figure it all out, something changes and you start over again.
Now, you touched on a couple of things there, and I do want to follow up on them, because you mentioned, I guess, how technology is impacting the workplace, I guess, just where people are buying, where people are working, and also you mentioned social expectations. In preparation for our call, and I have to thank you, but you've been writing and presenting a lot this past year, so it was a nice little spark notes for our conversation. You mentioned a few things, and one is that I think the average person might understand or be familiar with is telecommuting, and I guess how that impacts, how employment law impacts that, and how maybe what we know about employment law now might be applicable or not applicable to what's going on there. And you've been quoted in articles both talking about how millennial workers are showing a strong preference for open office settings and or telecommuting. And you also mentioned that if a company were to want to trim staff, eliminating telecommuting might be a way to encourage organic attrition, because people might just go elsewhere if they don't have the opportunity to work from home. I guess, how is telecommuting, I guess going off of what you were just describing, how has telecommuting influenced employment law, and how have employers sought to kind of maintain oversight, apply existing laws with their employees in this kind of more social friendly, or in some cases out of office environment?
Yeah, telecommuting really is a great example of testing that theory of laws that were applied for an economy that looked one way in one decade has evolved into something different. And if you think about the vast number of laws that just make common sense, if a bunch of people come to the same place, again, factory, school, hospital, to do their job, it's easy to picture how these laws would affect wages, safety, labor relations, whether you have a union, who your boss is, all that stuff. But when the worker is not physically there in the same, just physical space, may not even be in the same city, the delivery of what it is the employees are doing, that doesn't change. I mean, if I write as a lawyer, if I write a brief from my house or I write it from the firm, the product is the same. But as you are trying to figure out issues about things like worker oversight, when they get paid, how you monitor quality, those in many instances are not even legal issues as much as they are operating issues. But the law may not be as helpful to you. If I observe an employee in my company doing something inappropriate, it's very easy to take down old-fashioned personnel action notes and maybe you counsel the employee. But when the employee is far away and you don't see what they're doing, but the work product comes back through the computer okay, it's a completely different set of quality control issues. And that's one of the things that we saw very early in the telecommuting movement that that challenged employers because old-fashioned management techniques just didn't work. That generated a lot of writing in the space, not so much on the legal issues as it was the human resource slash management side of the equation. And the reason that I have spoken on this topic so many times about where millennials versus older workers are is that this is very much a generation gap that carves right through the current workforce. The millennials who came up through whatever it was, high school, college, even graduate schools, wed to a computer, many of them taking classes that did not require in-room attendance, expect that that's going to be the way the workplace will work as well. As long as I do my work, it's on time, and I'm cyber connected, then that should be good enough. Businesses that have been around a long time don't necessarily see it that way. So when they decide whether to keep or phase out a telecommuting program, yes, it's going to have an impact on workers depending on what their expectation was coming into the job.
And I guess following up on that, and I guess it's another topic that you've written a decent amount about, and it seems a little dry, but actually gets, I think, pretty interesting in terms of workers' rights. Some really bad flashbacks from employment law for me, unfortunately. But in May, you wrote about the Supreme Court, or Blank Rome as an entity wrote about the Supreme Court and Epic Systems. And that was a class, and I guess that covered class action waivers in arbitration agreements, and it determined that those are enforceable, and that settled a circuit split. And I recall reading cases, which I assume are pretty influential, 14 Penn Plaza, Gardner, Denver, and there's always been, it seems that there's been a long time debate over to what extent workers' rights can be negotiated in exchange for other considerations in arbitration agreements. And I know Forum has long been a negotiating chip that was fine. Substantive rights have not been. And in Epic Systems, it was a class action claim for unpaid overtime under the Fair Labor Standards Act. And the report that Blank Rome provided said, I guess the question was, can employees and employers agree to solve any dispute through arbitration? And Epic Systems indicates that that's a resounding yes. I guess as the trend for employers kind of leans towards looking at arbitration as a cheaper and quicker alternative to dispute resolutions, I guess, do you see, you're talking about how the I guess just the management and how we go about employment law is changing. Do you see Epic Systems being a real kind of game changer in terms of how worker relations are figured out?
I think the short answer is yes, but it may still prove to not be as dramatic as a lot of the commentary said it was. I think that throughout your question, your central point is the correct one. The debate is still very much framed around where the fight will occur, not what will the substance of the fight be. You don't have any of these decisions yet moving through the Supreme Court under the Federal Arbitration Act suggesting that substantive rights will be anywhere diminished as opposed to where the fight will occur. I am keenly aware that the plaintiff's bar does not buy into that interpretation. For them, the substantive right of going to court is a substantive right, and this is an end around to deprive not only the individual employee of their rights, but by not being able to necessarily bring a lot of them together, it may disincentivize the bar. Okay, so that's one side of the argument. It's not where my client base is. But having said all that, the fight is still over where the fight is. And arbitration has a funny cycle of how everyone thought it was going to cure every single problem that was out there. But over time, arbitration itself has also become much more formalized. There are a significant number of rules through most of the major services that mirror the federal and most of the state procedural rules with regard to discovery and cost shifting and access to live witnesses. But there are some significant differences, and it's all part of the contract that you draw up when you go to work somewhere. And I think that's just going to have to play itself out. But there's no question the employer side of the bar is much happier that these matters have to be resolved in an arbitration process than in court cases that often go on for years. And in many, many instances, the counsel fees and the delay becomes more about the case than the underlying merits. And to the extent money is owed, the employee is getting it to them. And if it's really not owed to them, getting a prompt hearing on that.
And finally, and I'm going to try to avoid my past few questions have been a little lengthy, so I'll try to make this one a little more simple. Epics in your Epic Systems post, the reference is also made to the Me Too movement, and I'd say, and I'm assuming you'd agree that the bulk of the public quotes that and presentations and webinars and guidelines that you've produced in the past year or so have been geared towards Me Too. I guess for those of us who only really know about this issue through the headlines, I guess how pervasive is harassment and sexual assault in the workplace, and has this been a real? Would you say this is one of, if not the most, focused upon elements of employment law over the past year or so?
In reverse order, yes, it's absolutely the most highly focused on. I was driving in this morning, and I won't name the network, but where a very senior executive who was just let go for cause as a direct outgrowth of this issue. So it is ripped from the headline stuff every single day. I think depending on your perspective on this issue, whether it is just a complete outpouring of publicity and an attention being thrown on an issue, or whether it is actually getting better or worse, is really in the eye of the beholder. The one thing that is not debatable is that more attention being thrown on this issue has definitely empowered more people to step forward, and where they believe they have been harassed or the victim of illegal conduct, there is definitely a greater willingness to bring those claims forward than existed before the Me Too movement really took off. The other is, I think, at the board level, you have companies being much more sensitive to not treating these claims as either frivolous or just automatically taking the side of the more powerful person at the company, or even the rainmaker inside of the corporate or other service firm environment. And once that occurs, two things happen. One is you focus on the individual case, and then you focus on the trend of how these are popping up. I think the vast majority of employers in this country try to get it right, and I think they try to run both a good and lawful workplace, and where they fall short, I think it is easier now to get attention to that and to get to court, and then the fight is on whether it really happened or it didn't. But there is definitely a spike up. Every government agency that tracks this will tell you there have been more complaints brought forward since the Me Too movement started. I think it's still too early to tell how many of those will prove to be meritorious or big meritorious, as opposed to a technical violation of something that just someone stepped forward to present. But the raw filing numbers are definitely up since this movement took place.
And I guess on the other side of that, there's obviously what you're talking about now, where people feel more empowered to come forward and I guess have these matters adjudicated on the merits. But I guess in terms of some of the advice that you've given, in terms of avoiding these situations altogether, I know you and some of your colleagues have authored a number of posts for both Blank Rome's blog and the Family Business magazine, and the suggestion that you've come out with is corporate messaging, I guess against workplace harassment, reviewing internal policies, preparing for internal investigations, and you've also even developed guidance for preventing sexual harassment at workplace functions, such as holiday parties, which are certainly going on right now. I guess one or two key areas of employment law or compliance that you've seen change, not necessarily in response to suits coming forward, but to try to prevent these kinds of issues.
The number one rule still remains the number one rule, that it has to start at the top. You cannot change or create a good culture at any place of employment if it's only a lower level issue or it's just some memo that comes out of human resources that everyone ignores. The companies and the firms that are the most successful in our view in heading this problem off, which means it never happens, is it starts with a culture from the top down that this is for real, that everyone is to be treated at work with respect, that the laws and the spirit of the law is to be honored, and that there is a very, very clear and easy to follow process if you believe your rights have been violated. I think it was common for some companies to, not that many years ago, they might have a toll-free number to call if you were a harassment victim, but it would be buried in page 97 of some manual. Now, we advise get it out there, make it easy to find, make sure that there is a way to find it and use it. And then the third one, which is perhaps it's not the most important, because I still think culture and directive is the best way, but ensuring a policy and a practice at work that no one will be retaliated against for using the process, even if their ultimate complaint is found to be without merit. The process itself just can't invite retaliation. And so if you have a place of work where it starts at the top, the procedures are easy to follow, and you set a very clear directive that no one will be retaliated against, those are the companies that tend not to find themselves either in legal trouble or the, in many instances, equally bad problem of just horrific customer relations or bad media fallout. And by the way, on this point, I know I'm giving you a long answer. The other real thing that has helped here is social media, in the respect that you can't hush these things up anymore, and you just can't sweep them under the rug, because if someone has access to a good social media network, they'll get the story out anyway.
Interesting. And finally, I guess to end our conversation the way we have with our previous podcasts, you've touched on a number of topics both here in Philadelphia and abroad that have kind of percolated not only into your job and the job of your colleagues, but I guess into the public dialogue, into social media. People are talking about Me Too. People are talking about telecommuting. People are talking about the minimum wage. I guess for somebody who's interested in this subject, maybe as a student, maybe they just want to be more informed, or as my classic example, a guy who wants to sound informed over a beer with friends. I guess what about employment law at this point in time is most interesting to you right now?
I think it's the thing that's most interesting to me is something we already talked about a few minutes ago, which is that it never sits still. There are changes that occur from so many different angles, whether it's a new law, a new interpretive regulation, a Supreme Court case that turns what everyone thought was the standard or the state of the law on its head, and then you mix all that in with a constantly changing and evolving economy, which is reinventing itself all of the time. And then I guess the third layer to this is that there's always a political overlay, whether you're of a liberal or conservative view. Those battle lines are always being drawn up. Employment law under the last administration is completely different than it is under this administration, and it will be different under the next administration, whoever that is. And that's, to me, the most interesting part about this, is that you can pick up any mainstream non-lawyer newspaper, and 3 out of the 10 front page stories are going to be related to some way the workplace. And maybe I end it with this, which is to say that some of this is, to me, not surprising. If you go back to the old line of when you meet somebody at a party, first thing you usually do is tell them your name, and then the next question is almost, what do you do?
Yeah.
And that is a somewhat uniquely American phenomenon, that we define ourselves so much by what we do for a living and the social circles that your job takes you into by definition. And so to see the amount of talk, law, commentary, social media around work, that does not surprise me at all. It's sort of who we are as a people culturally, and I don't ever expect that will change as long as, to be candid, the country remains a great economic force and a great innovator in terms of ideas in the workplace. So all these things factor into why I find it interesting. It's because all that stuff changes every single day when you get up. It's the old line, you can't cross the same river twice. You don't ever have the same workplace issue twice, even in the same company. And that keeps it interesting. It really does.
Excellent. Well, Mr. Cooper Scott, thank you so much. I know I made it a little difficult for you early on in connecting with us, but really appreciate it. And it's always a pleasure. And have a great holiday. I hope you enjoy it.
Well, back at you, and thank you so much for having me on there. You can tell from my resume, I love staying engaged and connected to Temple. It was always cutting edge. It always will be. And this interview furthers that the law review is in as good, if obviously not better hands than when we were there. So thanks for your time and bringing me into this, and I'll hope we can catch up again sometime on an equally interesting set of topics.
Sure, excellent. And I'll definitely save that quote for either my obituary or something. Something. I'll be sure to keep that one. I appreciate it.
Terrific.
Take care.
All right, have a good day. Bye-bye.
Goodbye.